Good morning and welcome to the Law Show. Bob Kerrigan with you this morning, and we're continue to talk about the various schemes and scams that defraud our senior citizens. We've talked about aspects of Medicare and all these supplements and advantage plans, etc., that are pitched at the time when you can sign up and supposed advantages of those. And then we've talked about the reality of giving up Medicare for a substitute insurance company that you really have no idea what they're going to insure and not insure. So I have taken a position, and I think it's not the position necessarily of, obviously, of the station or advertisers or anybody else, but my opinion is that there's real fraud going on, convincing people to give up something that they shouldn't give up, and in that case, Medicare itself. Now, we've also talked about various fundraising schemes that people come up with, and they call and say, for example, do you support our veterans? Well, yes. I mean, people would be unusual for a person to say no, they don't. And so they engage you in conversation. A lot of these start with robocalls, and then if you answer a couple of questions and you actually talk to a live person, they get paid based upon selling you whatever they're selling you. We talked about the percentage of your contribution that you make to the various organizations and how much of that goes to the fundraiser, the people raising money for the organization. The organization might say, well, hey, we don't care if we get some of the money. We're better off because we didn't have that money. So they really kind of look the other way, and the fundraisers decide, well, we're going to get in this and we're going to appeal to people's fear. These advertisements and these proposals across the board have a common denominator, and it's fear. So today I'm going to talk about the fear that the elderly have for dementia, for the development of dementia, and the multi-billion-dollar market of snake oil that's being sold to people ostensibly to enhance their memory when there's no scientific basis for it. So let me start, and I'm going to go through a lot of this. Today's program will be focused on Prevagen. You see all these advertisements for Prevagen, claiming that, well, they're cleverly done because they don't just out and out say, by golly, we can prove it, your memory's going to improve. I mean, everybody would just be flocking to stock up on this stuff. But that's not the case. These are things like people have anecdotally said, well, I've been taking Prevagen for 5 or 6 years, and I find my attention is much more focused on whatever. Well, you don't know if these people are loading up with every other kind of supplement that's out there. By the way, the Federal Drug Administration doesn't regulate these supplements. And invariably, they have disclaimers somewhere in their advertisements or whatever that these supplements are not guaranteed to do anything, but people take them. Now, for example, if you're deficient in vitamin D and you take a vitamin D supplement and your physician says that you should be to get your vitamin D level, that's entirely different from these general health food supplements. So let's talk about Prevagen. There was an article in the Journal of the American Medical Association, a very prestigious journal, entitled The Rise of Pseudomedicine for Dementia and Brain Health. Well, out of that article, they conclude that there aren't any benefits to any of these things that can be objectively and established and proved. Let me talk a little bit about testing and what these terms mean, okay? So you've got a product that you say is really going to improve a person's memory, and you want to test it. Well, the gold standard of testing is what they call a double-blind test, and here with a placebo. So here's how it works. You take a population of, say, 5,000 people, and 2,500 randomly selected, that's what they call randomized testing, randomly selected, they get the placebo, and the other 25 get the Prevagen, for example, or whatever the drug is that you're testing. if people administering it don't know which one they're giving. They don't know whether it's a placebo or whether it is the drug itself, like Prevagen, or the supplement like Prevagen. And the reason that's a superior method is that if you know which one it is as a physician or whatever, you might clue the person that's getting it that they're getting the real deal or they're getting a placebo. So when you have a double-blind test, the people giving it don't know, and the people receiving it don't know, and then they're tested later to see how that works. Now, there's some stratifications of randomized testing, breaking it down, say, to people over 50, people under 50, things like that. But that's generally how it works in randomized testing. So, first of all, Prevagen did a study themselves, a legitimate randomized double-blind test, and it proved that their supplement didn't help anybody. It didn't do what they said it was going to do. Those people that got it didn't perform any better than the people with the placebo. This article in the American Medical Association, the Journal of American Medical Association, was written by 3 prominent neurologists and dementia researchers at the University of California, San Diego. And they discussed this $3.2 billion that is made by selling these to people. And the reason there's a big market for it now is the increase. We live longer now, and that there is a greater incidence of Alzheimer's disease. Anybody that has dealt with a relative with Alzheimer's disease knows how tragic it is and how tough it is and how debilitating it is for not only the person that has it, but for the family dealing with it. So enter this outfit called Quincy Bioscience, and they're the maker of Prevagen, Prevagen, and they use a claim that they have scientific backing for what they claim Prevagen does. Well, the fact is they don't have scientific backing for it. And it says in this article that they lack essential features. Remember, I talked about the randomized double-blind testing of sufficient participant characterization, treatment randomization, and fail to include limitations. And these are published in what they call bad papers. Now, when they talk about a peer-reviewed article before it's published in one of these prestigious journals, other physicians have to look at it that are knowledgeable in the field. They have to test the premise, and they have to test the results, and they have to verify that, in their view, this is a valid scientific paper. No, this Quincy Bioscience didn't have that. They didn't have it at all. They cite to something called the Madison Memory Study. It's a study sponsored by them, performed by an employee of this company, Quincy Bioscience, and published in-house, meaning they publish it themselves, not publish it in a reputable journal or whatever. And in the world of real science, this type of study is ignored. I'm reading from an article from MedPage Today. I've talked about MedPage Today. I think it's excellent. The marketing, this article goes on, so the marketing for Prevagen is a clear-cut fraud from the label on the bottle to the ads airing across the country, said New York Attorney General Eric Schneiderman. The marketers of Prevagen have preyed on the fears of older consumers experiencing age-related memory loss, said Jessica Rich, director of the Federal Trade Commission's Bureau of Consumer Protection. But one critical thing these marketers forgot is that their claims need to be backed up by real scientific evidence. And it's not. So what happened? Well, there's a lawsuit that was filed. Enter the lawyers, what we do for a living. Okay, and there's fraud. Lawyers like to think that they're protecting society from it. I think they are in many cases. This was filed by the Federal Trade Commission and the people of the state of New York, and it was against Quincy Bioscience Holding Company, that company that I've told you about that makes Prevagen. Okay, so they filed this lawsuit. I'm going to just tell you some of the things they said in the lawsuit, and then I'll tell you what happened to the lawsuit. Okay. That Quincy actually conducted a randomized double-blind placebo-controlled study that contradicted their representations. The study showed no statistically significant improvement. So Quincy Bioscience did the study correctly, but it showed it didn't make any difference. The placebo people had just as good a memory or just as big a memory loss as the people who took the drug. Okay. The FTC has stated a plausible claim that Quincy's representations about Prevagen are contraindicated by the results of Quincy's clinical trial and are thus materially deceptive. Okay, so that was the lawsuit that was filed by the Federal Trade Commission. I'll tell you about that. So what happened to that lawsuit? It says that the FCT, by the way, the FTC alleges that Quincy's claim that the active ingredients in Prevagen, apoquarin, enters the human brain to supplement the proteins that are lost during the natural process of aging. That claim, this lawsuit says false. Well, where does this stuff come from? Okay, this is really funny, all right? If there is anything funny to all of this, it is that this stuff comes from a jellyfish's brain, and it's supposed to be beneficial to your brain. One of the problems is that jellyfish don't have a brain, okay, but it's supposed to be beneficial. As this one, I would just read some of the comments from the article that are made by just various people. And jellyfish have no brains, only neural networks. This is really a good one. Sea turtles must have great memories. They overload on jellyfish. One of the fewer that feed, of the few who enjoy fellowship, jellyfish as cuisine. Okay, so I'm just reading you some of the comments to the article, and I'll make another comment in a minute here. Old-time medicine shows go on and on. I can't figure out why jellyfish's extract will be good for anyone's brain. Jellyfish don't have brains. Several people knew that, which I actually didn't know. I should have known that, I suppose, from biology or something. Some course I failed to grasp that. And it's really helped my swimming, but I can't seem to remember how to get out of the pool. Okay. In order to get these products, they require you to sign up for automatic billing. All right. This stuff's like $30 to $50 a month. And invariably, the elderly are buying this to try to prevent this onset of dementia. And this summarizes it pretty good. Preying on the fears of an aging population. The common denominator we see over and over and over again. Preying on fears. Your identity is stolen every 31 seconds, according to the deceased Rush Limbaugh, as they were selling some program that prevents your identity from being stolen. Your house is going to be broken into. Your car is going to break down. If your car breaks down, you don't have insurance. You better get that insurance right away. Well, the judge that heard this case kicked it out. Kicked the FTC cases out, and that was appealed, and I read you a little bit from the appeal. So who is this judge? Lewis L. Stanton. Lewis L. Stanton entered this order that dismissed the case, bounced it out of court. Judge Stanton is 93 years old and on senior status, and the federal court allows elderly judges like this to participate if they're deemed to have their mental health and able to make good decisions. And I suspect that was, but it was just interesting to me that this case involved an elderly judge like this, and the subject of Prevagen was the subject of the lawsuit. Bob Kerrigan with you here on The Law Show. Thank you very much for watching us and for emailing and texting us, and stay tuned for more of The Law Show.
Kerrigan, Estes, Rankin, McLeod, and Thompson. May the fours be with you. Kerrigan, Estes, Rankin, McLeod, and Thompson. May the fours be with you. Welcome back to the Law Show this morning. I'm Mike McLeod. I'll be with you for Some of the show, the remaining parts of the show, is hosted by the lawyers with Kerrigan, Estes, Rankin, McLeod, and Thompson. Our law firm has practiced along the Northwest Florida coast for 40 years, and we've limited our work and our practice and our clients to people who've been seriously injured in accidents of all types. And we're proud to host the law show at this time on this station every week. Our firm specializes in these cases where people are seriously injured. And as we host the law show, we have a system whereby you can text us during the show if you have a question. The number to text us at, again, we mention it every time we air the show, of course, is our main number at our office, 850-444-4444. It's all fours. You can text us this morning at that number, or you can email me at my email address, mike.mcleod@kerrigan.com. It's on the screen now if you have a comment or question about the show, and I will reply. So I want to talk during this segment of the law show about how we prove one of the elements of a substantial case. And we've talked before on the law show about the 4 elements of a successful case. And they are: the other person or business or entity is at fault, the client has a real injury, real damages, and then the third thing we call causation, the accident caused the injury, and then finally there is a source of funds, or typically insurance, to pay the value of the case. So the second element is the client has a real injury. And so I want to talk a little bit this morning about, well, how do we prove damages in a serious injury case? And some of the things are very basic that really can be almost added. We used to say on a blackboard, but now we say on a laptop or computer, but things that can be added up. And those things typically are, well, what are the client's medical expenses that are a direct result of the accident and injury that was not his or her fault? So we get those medical expenses from the hospitals and doctors where our clients have treated. And at the point in time when we are evaluating, well, what is a case worth? How do we prove what has been lost by our client? We can add those medical bills up and we get a figure. This is what the client has had to pay, or his or her health insurance company, or Medicare sometimes has had to pay, and those expenses have to be reimbursed to the providers. So that's an element of loss for the client. So what are the medical bills? We can add those up. What are the lost wages? And so that again is something that's not very complicated, but if a person was working at the time of the accident and gainfully employed, had income, and because of his or her injuries in an accident, we can, through W-2s or tax returns or a comment or statement that we get from an employer, we can prove, well, these are the expenses, this is the lost income that our client has sustained. Again, it's a matter of kind of math, is that part of it. So some cases, clients will have future expenses even beyond the time of settlement, and future lost income even beyond the time of settlement. So we attempt to project, well, what are the future medical expenses going to be? And we use the treating doctors, and we get with doctors and providers to help us project, well, what is your estimate, doctor, of the future expenses for this client going to be because of their injuries from the accident? And then cases where people are unable to work or have to change jobs because they're not physically able to do the kind of jobs that they did prior to the accident, we are able to show those things as well, and we can project out what is the income that the clients are going to suffer beyond the time of settlement of a case. So those things, again, involve kind of math type things. But then people can be critically injured to the point where they are not able to do the types of things that they were able to do prior to the accident, and they really genuinely affect a person's quality of life. It's not lost wages, it's not medical expenses, but they are real lawful damages in Florida that people experience that were not their fault, that are the fault of a business or other person who was negligent and caused an injury. And so in those cases, we want to convey what a doctor might say about a person's limitations or how an injury might affect their future physical ability, their future pain. And so in those cases, we are able to, with the client's permission, meet with a critical treating physician, a physician who has good knowledge about the client's injury, their efforts to get better, and their treatment. And when we meet with those physicians, we can, in most cases, get them to assist us by evaluating, well, what does the future hold for this client? And physicians, and many times they're physicians of many types, neurologists, orthopedic surgeons, primary care doctors, pain management, anesthesia doctors, can tell us, well, this person is or is not always going to have low back pain, always going to have neck pain, not be able to raise their arms above their head without pain. So we want to be able to educate, in some cases juries, and in some cases insurance representatives, in some cases defense attorneys. Well, what does the treating physician, and we have terrific medical care providers in our Northwest Florida community, but what does the doctor project about the pain level and the ability of the client to enjoy activities of daily living and pleasurable events that they were doing before the accident? How's it going to affect them? So we meet with the doctors and we get them in different ways to help us convey this information. Now, sometimes the information is provided in the form of kind of a letter of evaluation, and those things are helpful. And at times we add to that information all sorts of information we can now get from the internet. For example, if a person has a fractured patella or a certain spiral fracture of a weight-bearing joint, all of these somewhat technical and medical terms, we can get visual illustrations of the exact injury, the exact surgical repair with metal hardware and screws, braces. All sorts of things are available from the internet that we can provide to the person or entity that is responsible for a serious injury, that goes along with the doctor's evaluation and projections that we ask for. And so we can provide that in letter form with visual illustrations. But in other cases, when we try to be creative in the way that we convey this information to typically an insurance company who's evaluating a case, because I think it is a lot more persuasive and descriptive and beneficial to be able to see and hear about the injury, and at times from the client. So we have had cases where we have, even before filing a lawsuit in a case, and a lot of cases are settled prior to a lawsuit being filed, we can have a conversation with a treating physician who's critically involved with the client's medical progress and care. And we can ask them questions. We can videotape a conversation where our attorneys will inquire, tell us about the injury. What's particular about this injury? What's limiting about this injury? What about the location of the injury that might cause the client to have future problems as they get older? Because one of the things that is very important to us is that we don't want to settle a case because a client has these problems today. We want to make certain that we are aware, well, how is the client going to be in 10 years? How is the client going to be as they age? Is this injury, which is near a joint, going to develop or likely to develop arthritis as the client ages? And so we need the help of trained physicians who know these things to help us educate an insurance company who's evaluating a case. So again, we can do it through videotaping a physician, and we've done it many times. It's a conversation, and it's, I think, more interesting than reading a letter or having me write a letter and saying, the client says this, the doctor says this. Well, we want to do it in a more persuasive and real way. And I think through today's methods, we can videotape it. We can have a conversation that's more interesting. An insurance company or a defense lawyer can see the doctor and see him or her answer these questions about a client's injury. So I think another very helpful way in significant cases that we can convey, well, what has this been like for our client? And that is, we can, and have many times in significant cases, we can have a camera crew at a client's home, and we can talk in person and on camera with a client about their experience after an accident and what their limitations are. So, you know, people that have these severe limiting injuries have trouble with all sorts of activities of daily living that it's just clearer and more persuasive if we see it. So, and we're going to do one of these this week in our office for a terrific client who has a very severe injury. But he has difficulty just getting out of a chair that he sits in his family room with his family watching TV. He has a lot of difficulty just getting up and getting down. And when he wants to eat something, he has to rest his elbow on a special table that's provided. And so it's a lot more persuasive, I think, and realistic and real to be able to see that and hear him talk about it as he attempts to do some of these physical things. Oftentimes people with these very severe injuries have trouble getting in and out of a vehicle. So we'll be able to show on a videotape our clients getting out of a vehicle, doing real day-to-life things that are difficult, that become very much clearer when we see them. So these are things that we do when we try and illustrate the gravity of real injuries to our clients. We do it in every case. So I hope that's helpful to show some of these things that we do. All right, we're going to be back with another segment of the Law Show in just a minute. And Mike McLeod will be right back. For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida. For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida. Welcome back to the Law Show. I'm Mike McLeod. I'll be with you for another segment of the show. We've been talking about the different and creative ways that we can illustrate the significance of our clients' injuries, serious injuries as a result of accidents that were not the fault of their own. Our law firm specializes in cases that involve serious accidental injury and wrongful death. For many, many years, our firm has elected not to do other terrific things that lawyers do, like real estate transactions, estate planning, very important, domestic matters, adoptions, criminal defense work. We have decided and years and years ago that we were going to only handle cases that involve accidental injury and wrongful death cases. We were one of the very first law firms in the area to limit our practice solely to those cases. And we've hosted the law show for almost as many years over the Gulf Coast area from Panama City to Pensacola. And this morning, we're going to go to the mailbag and answer some of your text questions to us. We have the ability to allow you to text us your questions and comments to the lawyers that host the law show. And the number to text your comments or questions now is 850-444-4444. It's all fours after the 850 area code. That is our main number at our offices. It's also a number where we can receive text comments about the show. And also, I'll repeat, my email address is mike.mcleod@kerrigan.com. It's on the screen now. If you have a comment or question, I can be emailed directly during or after the show. mike.mcleod@kerrigan.com. All right, so let's see if we can answer some of these or comment on some of these comments or questions. Here's one. What should I do if an insurance company calls me about my injuries? So it's very common after particularly an automobile accident for either your insurance company or the other person's insurance company to call you, contact you, and request that you give a recorded statement about your injuries. It's particularly common in cases where the other person's insurance company calls you because they want to inquire immediately gather information about your injuries from an accident. And I think the question is, should I participate in that or not? If it's the at-fault party's insurance company, that insurance company has a duty to the person who hit you, not to you. And so if you have no injuries or modest injuries or significant injuries, I think you should not necessarily rush to give a recorded statement right after an accident. Many times injuries develop days later after the accident. You're under no obligation to give a recorded statement to the other person's insurance company immediately. If you are planning to hire a lawyer after a serious injury from an accident, it's much better for your lawyer to make the decision based on the specific facts of your case, whether or not it's beneficial for you to give a statement. If you have very severe injuries from an accident, your lawyer can respond to the insurance company and say, without you giving a recorded statement, my client has a leg injury, he had surgery, he has pins and plates in his leg, or whatever the facts are for your particular case. But I think that you're under no obligation to give a statement immediately to the at-fault insurance company. Your insurance company is a little bit different because your insurance company should have a duty to you. They're insured after an accident, but they still will investigate the case in a somewhat of an adversarial manner and collect information about things like, were you wearing your seatbelt? What do you remember about the accident? How fast was the other car going? And then tell us something about your injuries. And then sometimes they say, well, tell us about injuries that you had or or conditions that you had before the accident, which could provide defenses to the case. But with your own insurance company, your contract of insurance may and probably does require you to cooperate with your own insurance company who is providing you with coverage. And so in those cases, you may be obligated to give statements to your own insurance company. But here again, if you are planning to hire a lawyer, or if you've hired a lawyer, you should get the lawyer involved in making that decision with you. And then one other comment about this question. If you've hired, and this sometimes happens, if you've hired a lawyer, it is improper for the insurance company, either insurance company, to contact you about the accident. And the reason for that is you've hired a lawyer to represent you, to handle this case for you, and it's not proper for insurance companies to run around your lawyer to get directly to you to see if they can get information from you or to communicate with you in any way. It's not proper. Insurance companies typically do not do that. Sometimes we've seen it on isolated occasions. It's really not the practice, but it doesn't happen because the insurance companies know this person's represented by a lawyer. It's the lawyer who I'm going to have to talk to and deal with. And the next question is, how long will it take for my personal injury case to get to trial? So, good question. And a lot of the answers to these questions start with, well, it depends. And so it does depend. But even cases that are more simple than complex require the filing of a lawsuit, of a complaint, and then the taking of depositions or doing other, we call it discovery, finding out facts and circumstances of the accident. And then the other side, the defense, wants to find out the facts and circumstances of the client's injury. So it's very typical in even the more simple case for that to take 4, 5, 6 months because depositions have to be coordinated and scheduled with the clients and with the lawyers. And then some depositions of treating physicians have to be scheduled so that we can provide sworn testimony from doctors about the nature of injuries. And that has to be coordinated with the doctor's office and takes some time. So I don't think it's unusual in even a more simple case for the discovery and all of that to occur, to take 9 months, sometimes a year. Complicated cases where there are more defendants, products liability cases where there are a lot of expert witnesses about the product, and those cases can take a couple of years, I think, in discovery, and it can be very frustrating to the clients and to your lawyer who wants to push the case to some conclusion for you, but that can be frustrating. And then I'll add this little bit to that question: how long will it take for my case to get to trial? Once discovery is completed and the lawyers are ready to get a trial date, the court will assign a trial date and will assign some deadlines to both of the two parties in the case. But with COVID, things have really changed in the litigation process. So our judges in the Northwest Florida area have been concerned about the safety of jurors, witnesses, other courtroom personnel, and so they haven't really been setting civil trials for a jury selection and jury trials because they are being respectful of jurors and others who come to the courthouse to participate in the process. And so just recently in the Pensacola area, judges have indicated that they won't be setting trials until late in the summertime, and that could be pushed off again. So for the last year, it's just been very difficult to get a civil jury trial scheduled. And that can be frustrating, not just for the participants and the lawyers, but I suspect for judges too, who are developing a backlog of trials that they're going to have to work their way through. So that is my best answer for that question. What is the statute of limitations for filing a wrongful death case? In Florida, the wrongful death statute of limitations is typically 2 years from the date of death. So if a person is killed in an automobile accident, the statute of limitations, which is the last day that a person, claimant, a plaintiff, can either settle the case or must file suit in the case to toll the statute of limitations, is 2 years from the date of death. So you have to file suit or settle the case before that 2-year period. There are some rare, I would say, exceptions to the 2-year statute of limitations. Some of them involve fraud and other unusual things, but the best answer is, I think, 2 years from the statute of limitations. All right, we've got a couple more questions and some time to answer them, I think. Can I sue my employer for a fall? And I'm assuming that means a fall that occurred at work. Good question. So let's see if I can answer this before our time expires. In Florida, employers are, for the most part, required to carry workers' compensation insurance for their employees. That means that if you have more than just a couple of employees, there's some exceptions to the requirement of workers' comp insurance. But for the most part, employers are required to carry it, and that will provide coverage to employees in the event of an injury at work. Doesn't have to be an accident, but an injury that occurs on the workplace. And so the benefits are that 100% of medical bills are paid for by workers' compensation insurance, and basically 2/3 of lost wages are provided by workers' comp insurance to the injured employee, no matter how the accident happens. So if it's somebody else's fault, if it's the employer's fault, in most cases, if it's the employee's fault who gets hurt, doesn't matter if it's your own fault. If you're hurt on the job in Florida, the basic rule is your employer provides workers' comp, your medical bills will be paid, and a percentage of your lost wages will be paid. The employer has to provide that as part of your employment there. The trade-off is that the employer who provides workers' comp insurance is immune from your suing them for your injuries. So even if a co-employee causes the accident, even if the employer has a somewhat unsafe work practice or workplace, you are in most cases prevented from suing your employer for that negligence, for that unsafe condition, because the employer gets immunity in return for providing workers' compensation insurance. There's some fine tuning of some of those answers, of that answer about workers' comp. I've got some more questions. We'll answer them next time on the Law Show. I'm running out of time for this segment. I'm Mike McLeod here for all the lawyers with Kerrigan, Estes, Rankin, McLeod, and Thompson. We're very proud to host the Law Show every week at this time on this station, and we'll be back with another segment in just a minute. Kerrigan, Estes, Rankin, McLeod, and Thompson. May the fours be with you. Looking for the number of an experienced personal injury lawyer? Look for our number. You'll see it everywhere. Looking for the number of an experienced personal injury lawyer? Look for our number. You'll see it everywhere.
Welcome back to the Law Show, brought to you by the firm of Kerrigan, Estes, Rankin, McLeod, and Thompson. I am Randy Thompson. I am the last name partner in the group. And so you got the bottom of the barrel to talk to you this segment, but I want to talk to you about negligence, specifically in the area of trip and falls and slip and falls, or what lawyers know as premises liability claims. A property owner, whether you're a private individual or a business owner of a commercial real estate adventure, a superstore, grocery store, any business that invites the public in, you have an obligation to maintain the property in a reasonably safe condition. It doesn't have to be perfect, but it's got to be reasonably safe. And you as the owner have to look for, be aware of dangerous hidden conditions on a property that could cause someone to trip or get injured. And it's your responsibility as the property owner to go around on a reasonable basis every hour, every 2 hours, and look throughout the property for areas that may cause a hazard to people who are invited on your property. So I want to give you an example now, and we'll put up a still photograph of a pallet of firewood that's sitting on one of our local grocery store's sidewalks. I represent a client who ended up being injured at this property. And so I want to talk to you a little bit about looking at that photograph, understanding what that photograph shows, and then we have a different view of that same area. This was taken by the store management after my client got injured. And so in looking at those photographs, do you think there's a negligent condition on the property? Do you think there's an unreasonable hazard there that may cause someone to get injured? My answer would be yes, I do. And although I'm concerned about that crumpled edge of the sidewalk there that you can see, because clearly the store knows it's broken. Clearly the store knows it's not level. Clearly the store, in my opinion, should know that that could cause a tripping hazard, especially to an older person who may not see as well. But in this particular case, it's that row of plastic, that string of plastic that's left hanging off of the pallets and blowing in the wind. Obviously, you can't see it blowing in the wind on these still photographs, but we have videos and the plastic is blowing around. And it's clearly, in my opinion, a trip hazard. What do you all think? Do you think that's a negligent condition on the property? Do you think that's an unsafe condition on the property that may cause someone to get tangled up and hurt? Even if that answer is yes, that's a negligent condition, we still have to prove who caused the condition. How did it get there? The law in the state of Florida says that if the property owner placed it there, then they should be aware of it and they have constructive knowledge of the condition. We took the deposition of the management of the store and they, in fact, said, yes, we put it out there. We directed that that pallet and that plastic covering that firewood be out there. And so from a standpoint of how did it get there, who caused it, we think that's pretty clear. The management of the store caused it. But then there's another question, because just because the management of the store placed that pallet there with that plastic on it, maybe the plastic was all contained at the time and it was tight around the firewood and it wasn't blowing in the wind and potentially reaching out to grab someone. So maybe the management of the store gets to say, but it wasn't a negligent condition when we put it out there. We didn't know. We didn't see any of the stuff blowing around in the wind. Well, watch this videotape. It won't take you very long. It's about a minute long, I think. That young man in the black works for the store. That young man is their employee. That young man walks by this blowing plastic probably 4 times. He had to come out right past it. He went right back in to the doors. He came back a 3rd time. Coming back the 3rd time, it looks like he's perhaps looking at trash on the ground, that piece of paper, but he doesn't do anything to pick it up. He doesn't do anything to make the property reasonably safe. He just keeps on walking. So, do I think that the store knew or should have known that a dangerous condition existed on their property? My answer is yes to that. I think they knew because when they set those pallets out there and they left them knowing that people in December would be using firewood, and they knew that that plastic would continue to get looser and looser. And despite that, they left it there. I want to show you a couple of still photos of someone who is not my client. This person, or these 2 men actually, that you see in this photograph, get tangled up in the plastic. And they get tangled up in the plastic about 30 minutes or so before my client, who ultimately comes along and gets caught in it. The store management wants to say, oh, well, those 2 men, they're the ones you should file your complaint against. They're the ones that caused this problem. That's not true. That plastic was out there blowing around, and these 2 gentlemen happened to get caught up in it, but they didn't fall. They didn't get injured. They just drove off. Well, what do you think if the store says, well, blame those men? They should have been down there. They should have picked that up. They should have called us and told us. It's not your obligation as a customer to walk around a store and tell the store what to do and how to be safe. So when you have a store and when you have employees who don't act reasonably, who don't take reasonable precautions to help and protect their customers, well, here's what happens. In this video, you will see my client and her husband coming out of the store, and at the very edge of the clip, at the very end of it, you see my client fall down. Ultimately, she had to have a complete total shoulder replacement because of the fall. Those are the damages that can happen, not to everyone. It didn't happen to the 2 gentlemen who also got tripped up in it. It didn't happen to the 10 or so other people who walked right over it and didn't get caught in it. But it did happen to my client. But now the store wants to say, oh, well, the fall is all your client's fault, Mr. Thompson. Your client is the only one that got tripped up in it that we know of. Your client is the only one that claims she didn't see it and she got hurt by it. So it's your client's fault, Mr. Thompson. So that's kind of the overview of how premises liability cases in Florida oftentimes play out. Sometimes the store management will say, oh, it was our fault. We agree. We acknowledge. We should have done better. But let's blame the injured person. The significance of blaming the injured person is that if the store convinces jurors that, let's say the fall was 50% my client's fault and 50% the store's fault. If the store convinces the jury that, well, it's all 50% her fault, then my client only recovers half of her damages. And her damages include the medical bills caused by the fall, the medical surgery, the anesthesia bills, the rehabilitation bills. My client was retired, but if she was unable to work, it would include her lost wages. But remember, if the store convinces the jury that it's 50% her fault, she only gets half of her lost wages. She only gets half of her unpaid medical bills. And that applies as well as to future damages. If she has to have future surgeries to remove certain hardware from her shoulder, or if she has to miss more time from work or attend more physical therapy. So the percentage of fault, the issue of comparative fault, is very significant. And if you are lucky enough to serve on a jury, and I do mean that, if you're lucky enough to serve on a jury and you're in a comparative negligence issue, lawyers will talk to you about that and they'll explain the significance of it. But it has real effects on a person's life. It has real effects on the store's pocketbook, right? Because if 100% of this fault is theirs, then the store owes all of the related medical expenses and lost wages. A jury could decide it's 90% the store's fault and 10% my client's fault. 95% the store's fault, 5% mine. They could decide that it's my client's complete fault, all on her own. I would think that would be an unfair verdict, but they could do it. It all depends on how the evidence comes out and who testifies, how they testify, the demeanor they have while testifying. And so all of those pieces of evidence come before a jury, and ultimately the jury is asked to decide, was the store negligent? What do you all think? I think yes. Did the store know about the condition? I think yes. Did the store leave it there for a long enough period of time that they should have known about it? I think yes. Was my client comparatively at fault? I say no. It's clear plastic blowing in the wind. She was walking with her husband, holding on to the cart. Those are things for y'all to think about the next time you go onto somebody's property and start looking around. Again, I'm Randy Thompson. I'm one of the partners at the Kerrigan, Rankin, McLeod, and Thompson law firm. We are always glad to talk to you about your claims and your injuries. Sometimes we can't do anything to help you other than tell you what the law is and tell you how it applies in your case. But we're always glad to talk to you. So feel free to call us. Look us up on the web at Kerrigan.com. And we'll be back again next Sunday.